When someone files a takedown notice on YouTube, they have to swear under penalty of perjury that they have a good faith belief that the use of the material in the manner complained of is not authorized by the copyright owner, its agent, or the law. As often seems to have difficulty catching every word in a sentence, let me emphasize the or the law part of this sentence. These seemingly trivial last three words require that the copyright holder consider if fair use applies to the use of their content before filing a takedown notice. Why do I think fair use is so important? Because it is. It's the other half of the copyright equation. Just as a copyright protects the holder's right to benefit from an original work, fair use protects other people's right to copy that content under certain circumstances. It's quid pro quo. Without fair use, copyright holders would have a monopoly on how their content could be used, and that would be totally un-American. Now, before we go any further, let me state that I am not an attorney, nor have I ever played one on TV, so nothing in this video should be construed as legal advice. I can, however, offer my own personal opinion about the concept of fair use as I interpret it from United States copyright law. Title 17 of the United States Code, Section 107, provides us a guideline consisting of 4 statutory factors that the court may use in determining whether the use of copyrighted material does or does not require approval of the copyright holder. First, they consider the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. This factor is broken down into 3 sub-factors: purpose, character, and commercial nature. The preamble of Section 107 lists 6 uses that are not considered to be an infringement of copyright. They are criticism, comment, news reporting, teaching, scholarship, and research. Of course, the court may entertain other valid purposes not listed here, but it's far easier to get the court to favor a finding of fair use if it's for one or more of these purposes. The character of use essentially refers to the degree of transformation you make to someone else's work. Simply copying someone's work verbatim would probably argue against a finding of fair use, especially if you claim the work is your own. But if you alter their work, put your own personal spin on it, use your own creative expression to change the character or nature of their work, then your work is transformative, which is probably fairer than making a carbon copy. Commercial nature simply refers to whether you're trying to make a buck off of someone else's work. This is probably the most important of these 3 sub-factors that the courts are concerned with. If you incorporate someone's copyrighted work into yours and sell it without giving the copyright holder a piece of the action, a court probably wouldn't consider that fair. Second, the courts consider the nature of the copyrighted work, or how worthy the original work is of copyright protection. This typically boils down to 2 sub-factors: whether it's published or not, and whether it's fact or fiction. If the copyrighted work is already published, then it's had exposure. People have seen it, and the content of that work has already been made public to some degree. Unpublished work has more protection under copyright law simply because no one's seen it yet. It's new, it's more marketable, and therefore more valuable to the copyright holder. The fact or fiction subfactor deals with the content of the original work, not the expression of that content. If the original work is factual, meaning it's about things that actually exist, historical events, things that are true and newsworthy, then that content is not protected by copyright law. You can't copyright facts. If, on the other hand, the original work is your own brainchild, a product of your own creation, be it an imaginative tale or some other inventive product, then that content is protected by copyright. Works that are both unpublished and creative probably get the most protection under copyright law. Next, the courts consider the amount or quantity and substantiality or quality of the portion used in relation to the copyrighted work as a whole. That means that using a small portion of a copyrighted work is fairer than copying the entire work, or what might be considered the heart of that work. Of course, the copyright holder may have a different opinion than you do as to what small means. To make this determination, the court may look at a couple of ratios. First, they might consider the ratio of the copyrighted material you use compared to the whole work. They may also consider the ratio of copyrighted material used compared to the amount of original material you add. A low ratio in both categories would more likely be considered fair by the court. On YouTube, for example, using 2 minutes from someone else's 10-minute long video would be fairer than if the original was only 2 minutes long and you used all of it. Likewise, using 2 minutes of someone else's material in a 10-minute YouTube video would be fairer than if your video was just 2 minutes long and included nothing but the copyrighted material. But even when these ratios are small, if your use of a copyrighted work isn't substantive or consistent with your stated purpose, then your use still may not be considered fair. The general rule of thumb is to use no more than is necessary or reasonable for your stated purpose. The last, and possibly most important of the 4 factors that the court would consider in determining fair use, is the effect of the use upon the potential market for or value of the copyrighted work. If you use a work that has monetary value, in other words, the copyright holder generates income through the sale or licensing of their work, then such use will probably not be considered fair, even if you give your work away for free. But the court also has to determine the effect that copying a work would have on the potential market for that work, and any derivative works, even if the original work is free. The main thing the court will look at to make this determination is whether your work is a substitute for the original work. That means if you're going after the same audience, or publish your work for the same intent and purpose as the original work, then that is not likely to be considered fair. Of course, a copyright holder could argue that severe criticism of their work might be persuasive enough to hurt the market for the work, but the effect of criticism doesn't have anything to do with the act of copying their content. In the United States, copyright holders do not get to pick and choose how their work is criticized. That would be censorship. Criticism is by its very nature transformative, and parody probably receives the most fair use protection because it's highly transformative and highly critical of the original subject, even if it's humorless or vulgar. For example, if were to attempt a parody of my work, I wouldn't expect it to contain any humor at all, but it could still qualify as a parody. Now, I'll let mull over what I've said here before I continue with the subject. I don't want to worry about him taking in too much all at once. So stay tuned for part 4, where I'll show and anyone else who might be interested how fair use likely applies to the use of content from his YouTube videos.